Hello, can you hear me? How many students today? Okay, we will start 10 minutes. 5 minutes. Okay, we will start. Can you see this screen? Hello, Naduni.
Hello, sir.
Can you hear me?
Yes.
Hello. I can't see.
Can see, sir.
You can see, no?
Yes, sir.
Right. Okay, good. So we will start. Last time we stopped here. That alternative dispute resolutions. Anyway, we will deeply discuss this today in my second presentation as well. So, alternative dispute resolution. So, in all the contracts, there will be disputes. So, because of that definition, the ADR. So, normally we are alternative dispute resolutions. There are several methods. We are saying that ADR include dispute resolution process and the techniques that act as a means of agreeing parties to come to an agreement short of litigation. So there will be as I said in the contracts, they always have a conflict. So there will be a disagreement. For example, you submit the variation or you are asking for the delay. So, contractor can requesting, but engineer refusing to give that. So then there will be a disagreement. So then you need the alternative dispute resolution method to resolve that one. To come for the agreement with by satisfying both parties or both or other parties. It is a collective term for the way that the parties can settle disputes with or without the help of the third party. For example, so if there's a dispute, as I said, the delay claim, contractor requests 7 days, engineer says 4 days. So then there's a dispute. So they actually both of contractor and employee can discuss the problem. The engineer can give his evidence and know his details. Contractor also can give details. Then sometimes contractor may miss some detail. Because of that, he claims 7 days. Sometimes engineer does not aware about the difficulty of the job. So actual scenario. That's why he certifying the 4 days. So the both party immediately they can discuss and resolve the problem. ADR typically includes early natural evaluation, negotiation, and conciliations, mediation, and arbitration. So I will discuss these things. Why use ADR in the construction? You know that there are so many stakeholders in the construction. And in the say one project, there will be a different contracts. For example, civil work will give to the one contract. Electrical work give to the other one. Okay. So AC work will give to another. There will be another one supplying the tiles. There will be another contract. So then there will be a disputes can be happen between the two parties or more among the stakeholders. So normally all are understandable that ADR, the alternative dispute resolution methods, are very faster than the litigation. So cost effective. So time with less time. Preserve business relationship. If you are going to the legal action, so that will be a end up your business relationship with the other party. For example, one developer going with the certain number, say for example ABC contract. So they are very good. So they have done several projects, but in one project they have good reputation as well with the same client. But unfortunately, because of one incident, if they go for the litigation, then the client never give another project to them. So they will they think they are always covering people. So that's the main very important thing in the litigation list. And also these things are that negotiate something. For example, some technical matter. So you are doing the houses for the outside. So any technical matter. So for example, concrete strength is not achieved by the columns or what. You want. So there are so many technical methods to rectify them. So the blame is go to the contract. So they give the proposal for the enhancing or fiber wrapping or steel jaggering like that. Whatever enhancing method will propose, and the cost will be bear by the contractor. So if there's any dispute about this, then that detail that the concrete quality is not there, not sufficient. Strength is not sufficient. The detail going to the outside is a very bad for the business. So people scared to buy the part. but you know how to rectify that. That's what that's what I'm saying that it's a private and but in the negotiation time you agreed no that the damage can happen to the outside for the business will be minimized. I will discuss this later as well. So just that dispute resolution, the legal dispute resolution and alternative dispute resolution, adjudicatory process. Dispute process, the adjudicatory process, the process with judge, jury or arbitrator determine the outcome. Litigation, for example, arbitration and litigation considered as a legal process. But the alternative process, the process with the parties each to reach an agreement, mediation and negotiation. These are the advantages and disadvantages of the ADR methods. As I said, it's a confident, detail will not go outside and time effective. So because if you go the legal action, they take so many times, so many hearings, take times and also money. So you have to pay for the arbitrage. So you have to pay for the lawyers. Okay, so that will be a cost. But negotiation also there you have to pay for the negotiator or meditator. But the cost will be considerable low value. As I said, preserve the relationship. Area can be a less advisable and hostile way to the resolve the dispute. For example, an experienced meditator can help the parties effectively communicate their needs and view to the other side. This can be important advantage where the parties have a relationship to preserve. So advantage of ADR is another increased satisfaction. So all parties are finally satisfied. So if you go for the litigation, so it will hurt other party, losing party, so that it will hurt for them. So always ADR give the win-win situation. And also very suitable ADR for the multi-party disputes, as I said. So if you have, so many stakeholders, contractors in one project, so litigation may be more complex. So you better go for the ADR methods. And also there is a disadvantage in the ADR. So the ADR most of the cases they give a court protections, including decision by the judge or the jury under formal rules, evidence and procedures, and review the legal errors by an applicate court. There is a less opportunity to find out the other side uh, cases with the ADR. So these are the ADR type I will discuss in separately. So the lectures. So negotiation and dispute resolutions. So today these are the content of the today lecture, mainly effective communication, why you need the effective communications, and also alternative dispute resolution area. I give a brief, but I will discuss more in this case.
Sir, excuse me.
Yes.
We can't see the PowerPoint, sir.
Give me 1 minute. Can you see now?
Now we can see, but thing is the theme, it covering some words which is contained on the
Now,
PowerPoint.
now,
Yeah, and that's okay.
right, okay. So these are the content of today's lecture, that effective communication. Again, I'm discussing detail-wise alternative dispute resolution methods, negotiating for dispute resolution, and role of responsibility of the negotiator, and also introduction to the arbitration process, importance of the planning stage, and the litigation process. So effective communication. Why you need the effective communication process in the construction project? As I said, there are so many stakeholders in the construction, especially in the mega projects. You will have a sometimes it's more than 1,000 different suppliers, different professionals involved, likewise. So because of the miscommunication can be a delay, cost overrun, and the disputes. So clear communication helps align the objectives and expectation from day one. So relevance to negotiate and dispute resolution. Disputes are often caused by poor communication. A lot of disputes are arising because of the poor communication. The contract document also allowed to give a clear notice method, how to give the methods, with the process they are clarified to minimize the disputes. So if you have a better communication methods, it will be a better negotiate. They will trust and handle tension calm. Engineers involved in dispute must translate technical complexity into the understandable language, because you know that in the construction project, what is the main communication method? Can someone give an answer for that? Especially in the construction project, what is the main communication method? Mudita, can you answer that? So anyone can answer for that? So in the construction, the main communication method is drawings. Your requirement will put it into the drawing and give it. Now there are so many methods, but the drawings are the key element. So proper drawings will reduce the conflicts. So understand communication fundamentally through high-stake discussion techniques links to the engineer dispute scenario. What is effective communication? So it is a clear, consistent, purposeful transfer of information. Goes beyond language. Sometimes tone, body language, timing, importance in technical high pressure environment. Because construction is a very tough work. People are very pressurizing most of the time. So, for example, you are giving to the mason wrong drawings. You are giving the verbal instruction to the contractor. That's not a proper communication. You have to give a writing, whatever, or give a revised drawing. So that is the effective communication. So any loose methods will cause a cost overrun and conflict. So elements of effective communication. So there should be a send and receive in the construction project. So most of the specifications, drawings, letters, contractual letters given by the engineer to whom contractor in the contract I mentioned in the previously FIDIC and CEDA, you have to appoint a contractor representative in the site. So engineer is a client representative. Engineer will give the instruction, everything to the contractor representative. So same vice versa, that contractor is giving his bill, request for the information to the engineer. So there should be a clear send and the receive. So, and also it should contain message content is more important. So because that is technical, contractual, and interpersonal. So sometimes contractual letters. One thing is your completion day. So you have to hand over the project. So you have to, as per the FIDIC, you have to inform the engineer before 7 days to take over the project. If not, engineer can postpone that one. So likewise, and any delays beyond the completion date will be a penalties for the contractor. So then it's a contractual way. And also medium can be email, meetings, drawings, reports. Now there are so many softwares, I will come and discuss that one. And also feedback loop, the confirmations. Once you submit the letter, you have to get the receive signature. Or otherwise, you have to go send through the registered post. Nowadays, we are not using the registered post most of the time, but you have to hand over letters properly and get the signature and keep the ledger updated. So context will be a legal, cultural, and also emotional. So barriers to effective communication. Technical jargon and misunderstandings. Hierarchical communication breakdown. Language and cultural differences. Because now we had a problem. The Chinese, for example, Lotus Tower, the design and build contract by the Chinese party, review and supervised by the local engineers, University of Moratu. All the drawings done in the Chinese drawing standards. For example, so the beam sizes, beam numbering, all are different to the normal local system. number of reinforcement bars. Locally, we are draw all the reinforcement. But Chinese drawings, they are giving the numbering. So language and also talking to them, their language, that also very difficult, Mandarin. So you have to recruit a person to give a proper translation. And also document control and access issues. For example, lower level site staff, they cannot access the contractual document. They don't aware what are the important factors in the contractual document. So these are the most important point, and you have also should know about these things. Can easily ask in the exam as well. You have to explain with the examples. So you are as a procurement one, you have to tell with your experience how the communication will affect when you are procuring construction materials, construction contracts. Procurement is not the only material only. The contracts you have to procure. Communication in negotiation, building rapport and the trust, active listening, both reacting, arguing. So when you are going for the negotiation in the communication, so when you are both parties listening to each other, and also non-verbal signals and emotional intelligence, using silence strategy, summarizing and reviewing conflicts. This is taken by the Harvard negotiations in the projects. Role of communication in dispute resolution. So there are several dispute resolution methods. So negotiation always delay. Meditation, neutral facilitator relies on the structured dialogue. So that means both parties have to write and the proper manner. Education, submission of factual, consistent written submissions, arbitration, formal legal agreements you have to have for the arbitration, and also litigation, evidence-based presentation. So you have to give the evidence to the court. These are the practical tools and technique in the communication what we are using in the sites. So meet in minutes, very important. So even attendance also very important. You have to get down the attendance, who is participating, government organization, who is working in the government office. Hello.
I'm working in a semi-government, sir.
Yeah. So you are working on with the minutes.
Yes, sir.
Right. Are you signing the minutes? Your superiors are signing the minutes end of the meetings.
Yes, sir. Before the sending other responses, we are signing the minute.
Yeah, that's it. So minutes is very important. You have to need to get the signatures, relevant parties, and also RFIs. What is RFI? Request for informations. Because in the construction, some drawings, some details are not there. You are giving the handrail, but you are not giving the what is the size of the bolt you have to use. Then the contractor has to ask written. Please inform the. Please give the detail of the fixing detail. If it is not included in the BOQ or price in reimburse, You have a claim on that. And also daily logs. You have to, day to day, you have to, every day you have to mention how many labors, how many materials are there. Because if there's any delay happen, you have to tell my excavator is idle in 2 days. You have to prove it. Otherwise, you can't claim. Okay. So then the daily reports, daily logs are very important. Nowadays, you can give it the videos, photograph. Now technology is more advanced. But same time, you can edit the pictures and the videos. I'm not talking about that, but keep the videos and things are performant. Then the emails, transiting emails, templates, protocol, managing remote communications and hybrid team. These are the modern tools. The project management nowadays commonly used in Sri Lanka base camp. The symbol is this yellow color one, base camp. So all the minutes, everything we are not circulate to each another. We put it into the cloud. Cloud give a more facility. It will give the deadline to approve the drawings. Deadline give that it will show the when the material are delivered from which side, that which port. All the details are there. You can monitor. There's another one, click up oneday.com. So those are the very important project management tools. And also construction tools, Aconex. Through the Aconex, you can submit the RFI. You can give the specific number. You don't need to maintain the registers with this technology. If someone not approved, so for example, you send the RFI, request for information, architecture, and you give the reference to the architecture and structural engineer both. But structural engineer replied, but architecture not reply. Then there will be a conflict. There can be a conflict. So all the construction drawings you can upload in the Aconex. Very easy to find the drawings. So you have to use the technology. Yes, when the technology is coming, it's very difficult to change. But with the changes, it's very easy to do the work. So understanding contractual time frame and dispute mechanism in the FIDIC reg book. So this is I'm going roughly, and I'm not I'm talking especially for the knowledge base. So contractual most of the contractual claims and the communication methodology requirements are covered in the FIDIC contractual document. So this is a key timeline for the contract events. So tender period they define. So I'm not going detail, just for your information, these slides, these 4-5 slides with reference to the FIDIC document. And also time that all the contract document, the time communication that through the contract document communicate the how to submit the bill, how to give the tender, how to give the time for completion, test on completion, like. And also when to submit the performance invoice. So I will share this slides with you. Tender and performance timeline. So tender period normally 28 days defined in the FIDIC. letter of acceptance, and so performance. So within the 28 days, you have to give the performance security. After receiving the letter of within 28 days, you have to give the performance security. The time bar is marked there. Commencement date. So you communicate through the contract document and also return of performance security. So this is how the bill should we go. It should be communicated to engineer, and engineer will give it take 28 days, and you needed 56 days to get the payment. So because engineer need the time certified, once the certified as well, that client also needed time, some time to organize the funds. So this is a defect liability period, defect notification period stated in the appendix to the tender. So defects may be you need to communicate to the contractor. It can be done by I discussed this in the defect liability period issues lecture notes, so that it can be communicated by the engineer, or otherwise client can employee can so employer can give the notice. Client can give a notice to the contractor if any defects appear. And also test on completion and delays. So if you have to do the testing, you have to inform, you have to communicate to the engineer. So specific dates, requirements specified in the contract clause 9.1 FIDIC document. And also the contractor's time for the completion, extension of time, and also delay impact of taking over certificate issuance. And also dispute resolution. So in the clause 20 dispute adjudication process, it's mentioned how to set up the DAB. DAB means dispute adjudication board. So they involved to resolve the dispute. It is in the contract how to do it, how to communicate, how to write, and also structured timeline aids fair dispute resolution. So this is a dispute resolution process that after commencement date within 28 days you have to establish a DAB. These are relevant to the FIDIC, not for the SIDA also same, but this kind of no details extend to this level. And also decision notice, if there is a dissatisfaction within 28 days you have to inform. Likewise, there are all the communication requirement given there. Okay. Today is a major part is the alternative dispute resolution. So I mentioned few ADR methods. Can someone tell what are the ADR methods you know? Mudita, what are the ADR method you are using in your office or your working place?
Arbitration, sir.
Sorry.
Arbitration.
So you are going for the arbitration in your office?
Yeah.
Before that, you have not done any negotiation or anything?
Because we are basically doing procurement based on the goods. We are not going for the dispute resolutions because we are doing the procurement based on the goods. Therefore, the procurement guideline has given there is no possibility to negotiate. Then we have to go for the arbitration.
Yes. Good. So, but in the construction, it will be different. construction dispute usually include only questions. But if efforts, design, construction, or both are issues. Whose scope of work is involved? Who is responsible for delay? Normally, common questions: who is responsible, employer or contractor? So likewise, then there will be a concurrency of delay. Most of the contracts now employs reduction the scope. So he will start with give all the scope to the contractor. The contractor also distribute his overheads to all the activity costing items. But the project is going if he want to reduce the scope of the contract and try to saving some money, or to give a reduction in the scope because to expedite the work. So these are the disputes: extension of time, prolongation, liquidated damages. For example, when we are doing the Lotus Tower, the client from PRC said, he said as per the contract, we have to apply the LD. But there are concurrency delays as well. But government-wise, if the date of completion date is exceed, then you have to apply the LD. If not, you have to grant a proper EOT for them. Such kind of legal background for the government organizations. That the common construction industry dispute is a delay. As I said, most of the constructions are delayed because of the lack of detail, lack of commitment, several issues, and the concurrent cause of delays. Concurrent being what both parties responsible for the delay. Same time. For example, you hand over the site. You hand over the site, but you agree to provide the water. But contractor is delaying the mobilization. He putting without water, he can't come. He can't mobilize. But there will be a dispute then. Then employer can say why you have take over the land. So likewise, there can be disputes. So most of the delay analysis we will do using the programs and delay charts. As I said, we have a very good tool, MS Project, Primavera, so you can easily analyze these things. And also we need sometimes technical expert witness evidence to resolve the disputes. In the Cinnamon Life project, we have to do the piling. So the rock boring they specified to go 3 meters something. But contractor said it don't, because of that it's delayed the project. Contractor said you don't need to do the such kind of rock anchoring, rock shocketing. So then they brought the expert, University of Morocco. They hire the University of Morocco geotechnical engineers, and they prove the shocketing no need. You don't need 2-3 meter more. examination and opening up of architects, engineers, certificates were fair and reasonable extensions of time considered. It's time at large. What is the time at large? Can anyone explain? Vijita? So time at large is the project there. It's not no proper definition goal, no proper completion date is defined on that. But you can't track that. You have to see, you have a time at large, so you have to reasonably complete the project time. And also
Sorry, sir. I was driving.
Yeah, I asked him what is the time at large. So I explained that so that no definition for the completion in the contract, but you can't take more time than that. So you have to have a reasonable time. You have to complete the projects. If not defined.
Okay, sir.
So dispute related to the claims for payment. So examination of payment certificates, examination of quantities, interim payment certificates and final accounts. There can be a lot of disputes. Claim of entitlement and valuation of variations. Reason for non-payment. Example, counterclaim for the damages. What is the counterclaims? LD. Employer can put he's not paying bill. He said you are delayed the project. Counterclaim, you getting applied the liquidated damages. So dispute arising. Legal and equitable set of issues. Interest claim. You are not paid. You have not settled the payment. For example, 1 million, 10 million pay bill. You are delayed 2-3 months. Who will bear the interest cost? Because contractor spend that money. So then it will be a interest cost, interest claim. Understood? These are the common construction industry disputes. Dispute relating to the alleged defects and non-compliance with specification. Non-compliance, we call NCR. So normally, engineer cannot deduct a bill without proper NCR. You are constructing the block work. If you are engineer not praise NCR, what you say the NCR is non-conformity. Non-conformity is what? The given drawing source specification. If I have not made that one, then the non-conformity arises. So that will be a dispute. Contractor can say, no, this is the correct. Engineer say, no, this is not correct as per the requirement. And loss and expenses and damages assessment. Losses. So dispute relating to the scope of work often involve issuing concerning specification, quantities, variations, quality of fitness and purpose. So categories of dispute resolution. That's what I told you that there are two methods mainly. So judicial dispute resolution and the alternative dispute resolution. So that means disputes are resolved by the court or tribunals. That means the arbitration also we can consider as that. Alternative dispute resolution also that resolved outside the court. Dispute resolution process, adjudicative process, the process in which judge or jury or arbitrator determine the outcome. So these are litigations and arbitration. Alternative processes are the process in which the party try to reach an agreement. So disadvantage of the ADR. I think this we discussed in the earlier slide, so we skip this one. These are the I include the earlier one as well. So we'll start with the negotiations. So negotiation is a dialogue between the two or more parties, which is had with the intention of reaching the understanding to resolve the point of differences, to produce an agreement to craft outcomes to satisfy the various interests of the parties involved in the negotiation process. That means two or more parties. If you have a conflict, dispute, so you should have intention to resolve this one. Without that, you can't go for the negotiation. Sometimes you are going, you come, I will never keep a leg down. I will not give a one censure to them. You are going to the meeting like that. So then your intention is not there. Understand? Then the both parties has to have a clear intention to do it. And the final agreement should be agreeable for the both parties. And after that, you can't say I'm not agreeing on that. That's not fair. You can do that, but it's not fair. So, misperception about the negotiation. Extreme claims, followed by small, slow concessions. Bluffing and lying. Threats or warnings. Benefit the other party alternatives. Good cope, bad copes. Take it or leave it off us. Personal insult. Ruffling feathers, feathers. So conciliation. So that is another ADR method, which one or more independent persons selected by the parties. So contractor and employer, they selected the parties. Negotiator can come, the expert or like that you can come in. But here the parties will select that guy. Either timing of making agreement subsequently when the dispute has arisen between them, to bring about the settlement their dispute through the consensus between the parties by employing various persuasive and other similar techniques. It is a process of the confidence and faith. This is also very similar to the negotiation, but the most important part is one or more independent person. I think someone phone is someone using the screen. PC Pradeep. Meditation. In meditation, is a impartial person called a meditator help the parties try to reach a mutual acceptable resolution of the disputes. So impartial person, you are calling as a meditator. He is not going to give the solution. So he is a meditator. He helped to other parties to give a come to the amicable settlement. They will resolve themselves, not the meditator. And also that good thing is the meditation leaves control of the outcome with the parties. He only help in that. So these are the advantages and disadvantages. You have to thorough in these things in the examination. Mediation may be particularly useful when the parties have a relationship they want to preserve. So when the family members, neighbors or business partner have a dispute, mediation may be the ADR process to use. Give me 1 minute. I have to small call. Give me 1 minute. I will come back. Sorry, I am not well today because I have to go to my. Okay. So when family members, neighbors, or business partners have a dispute, meditation may
Sir,
be.
excuse me.
Yeah.
With regarding PowerPoint that you have already uploaded to the LMS has given up to type of ADR. Rest of the part, how
Yeah.
can I get
No,
it?
no, I will give this today. This is today is a new chapter of this one. I will have send to that university. Okay.
Okay, sir. It is better if you can drop into the chat box. We can download it.
All right. Chat box. Wait. Okay. I put it that way. Meditation also effective when the emotions are getting in the way of resolution. So that also very that when you have a emotional thing, that's the meditation is the best way to resolve that. An effective meditator can hear the parties out and help them communicate with each other in an effective and non-destructive manner. So that the meditator can calmly talk to the both parties, because that defender or other, they will not hurt the meditator. So meditator also will not hurt any party. So he's a facilitator. So meditation may not be effective in one of the parties is unwilling to cooperate or compromise. That's what I said, that meditation or whatever, you should have a intention. Meditation also may not be effective in one of the parties have a significant advantage in power over the other. For example, so you can see that in the very low labor contract. So when we are, for example, we are doing so the TRC is one project. So they said they will deduct the LD. They have a more power. So they said, if you want, you go to the court. I am not going to pay that. If the court say pay, I am going for the Supreme Court. If the Supreme Court said I will pay, that means they have a more power, because they are backing up with the government legal officers, because money will spent by the government, so they have a power. So they will not easily negotiate and do that. That's one student said that they are not going for the negotiations. They go for the arbitration or litigations. Therefore, it may not be good choice if the parties have a history of abuse or victimizations. So this is the expert determination. Can someone tell what is the expert determination? Do you have any experience on that? When you're purchasing some materials, are you getting expert determination when some conflict coming or some confirmations? Are you getting consultancy from the outside? Can anyone tell that?
Sir, now once we are getting purchase something, that means chemical item, we ask the suppliers to submit the report from the independent body, with contains amounts and the purity level. The analyzed reports need to be submitted along with the shipments.
No, that is for the consultation. When the dispute, you take some material. Their test report is some different parameters or something. But you can't accept because you are asking something. But supplier say this is a similar to this. Then you need the expert determination. Someone has to guarantee. Likewise. Understand? In the construction industry, it's more commonly used, especially structural MEP works, because if there's a small crack coming, so engineer say I can't accept this concrete. Contractor say this is a normal, because the concrete is a crack, always crack. It's not a harm. So they referred the NBR or University Mora to a whatever expert position. So they will come and say, they do the investigation and say, this will not be a harm. This is a comply with the standards. Likewise, understand? So expert determination is most important in the conflicts. This is process also very speed, very quickly you can do it, and cost wise also very cheap. The same thing happened in one of the house, because when we are doing the concrete, we say pile cap construction, some cracks are appeared because that said we are saying the segregation. So that because of heat, high heat, there will be minor cracks on the top. The client say, I can't accept. I don't need the crack concrete. But contractor say this is normal. This can be happen. We will rectify. Client say no. I don't need the rectified concrete. I need the good one. Who bear the cost? Contractor say he can't bear the cost. This thing can happen. So then they went to the contract concrete consultant. Said, and we get the determination. And he explained to the client. He assured us. He gave the assurance. This building will not fall because of this. So
So cracking may be happen because of the curing. Curing will be
Curing
curing
also
will be done.
there can be a shrinkage crack. There's most of the concrete shrinkage cracks are there. Okay, because of the humidity, everything. Curing is we are putting the water to give that's a technical term. So that is give the we are preventing the evaporating water in the concrete. Cracks can happen due to the lack of curing as well, but there is another reasons. Okay, but the cracks can be rectified. That's not the contractor's argument. But the client said, I can't accept this one. I am paying for the concrete. I need the brand new one. But he said, if I buy a vehicle, if it's a scratch in the body, I am not taking. But the construction is a little bit different on that. This is not the manufacturing. This is a construction. But here, if the expert decisions come, if we get the expert decision, so then other disadvantage of this one is no right of appeal. We can't go and say this is wrong or what. No, we are getting the concrete professor's determination. Then again, client can go and tell both parties agree to go hear that part. If they not agreed, no matter. But if you go for the litigation, they also refer the third party consultant. But if you go for the expert determination, what will happen? Either party cannot appeal. These are the advantages of the expert determination. So dispute arise between parties. The expert is instantly available. For example, in the Lotus Tower, he had done there's a dispute, actually dispute, the proper dispute what we had. So the design, I told you Lotus Tower is a design and built by the Chinese company. They have given you can see that concrete mask top of the flower. That is a 187 meters high concrete mast. The thickness of the steel, that mast, 30 millimeter. Then lot of our panel of professors, structural engineers, they analyze, but they also don't have experience. They have not done such a big building. They say this thickness is not enough. You have to go for the 35 millimeter for the fatting. So where because the mast is for the fixing the antennas. So when you are to fix the antennas, you have to make a hole. When you put a hole, that area getting weakness. So therefore the 30 millimeter is not enough. You have to go for 35 millimeter. So then what was happened? Chinese people not agreed on this. Then I'm working to the University of Morocco that time. So we insist them to go to the 35. They said if you want, we can go to 35. It will be a claim. Then it will be a huge amount, around $1 million like that. It's a huge amount on that time. Then what we go for the international wind engineer. His name is John Holmes, one of the favorite, one of the pioneer in the wind engineering. He did the desk study. The study mean that with the available details, he has do the analyzing part and say, yeah, our argument is correct. The 30 is okay, but if you have a hole, it should be a 35. What was happened? This one we did with our consent, not the contractor. Contractor say we cannot accept it. They give a lot of inquiries, but but we paid for the desk study only. Those are the international consultant. He said he can't. He said he's not. He said this is his decision. He don't want to see the Chinese contractor clarifications, and also very difficult to contact him. He's in Australia. He's not instantly available. Okay. So when you're writing the questions like that, you have to give don't write in the point form to explain what is the practical problems in these ADR. So, but here I mentioned expert is instantly available. But if you go for the international one, he is not available like that. The locally, yes, but internationally we went for the international expert. So that is a different. The contract is required to continue the performance of the contract during the period of determination of dispute take place. Because sometimes he has to continue the work. That's what mentioned. Contractual relation does not come to end. If you use the expert determination, that contractual determination, that contractual relationship will not damage. Understood? So if you are not agreed, you can say not agreed. We will forget about that. So we will have a 15 minutes break. Okay. I am also today a little bit tired and I'm a cough and little bit fever. So anyway, we will complete today. We will have a 15-minute break. Okay, we'll start. Adjudication. Adjudication is a preferred dispute resolution mechanism in construction and engineering contracts. So there is an adjudication clause in the contract document. PD, and also there you can see these things. So that is a give a contractual provision. Okay, contractual provision to give a appoint another party, third party, especially third party, to resolve the disputation, resolve to the disputes. In the FIDIC, there is a specifically say you have to appoint a ADB, Adjudication Distribution Board. So they have a so the both party has to pay for them, and they have a responsibility to visit the site, and also that they have to actively involve the project to identify the disputes timely and resolve it. There are two type of adjudication. One is a statutory adjudication required by the law of the construction disputes in normally UK, Australia, and Singapore. Other thing is the contractual adjudication. This is a most standard forms construction contracts. As I said, FIDIC, SIDA. So you can see SIDA document is SBD 1, 2, 3, 4 like that. So arbitration. Arbitration is a procedure in which the dispute is submitted by the agreement of the parties to one or more arbitrators who to binding a decision to the on the dispute. It is a legal. The arbitration one is a very binding to the accepted by the court as well. In chosen arbitration, its parties opt for the private dispute resolution procedure instead of the going to the court. As I said, you can use the arbitration. You don't need to go to the court, but you can use the arbitration. In Sri Lanka, there is a called Arbitration Act. The number is 11 of 1995. So this is passed in the parliament, and it's now legally binding. So this is our the main Arbitration Act. So arbitration is an alternative dispute resolution area, one of method, but it's provide a private legally binding method to resolve the disputes. Common in construction, commercial, and international contracts. There's a lot of in the international contracts. For example, international contractors, they put the arbitration panel not in Sri Lanka, outside the country. You may know that Celestial Tower in the 2014, end of the 2014, now like that, they have given the interior design to the Italian company consultant, and they in that contract the arbitration panel should from the hearing should be done in the Singapore. Okay, so unfortunately or fortunately, it's the government change in the 2015. Then government decided to stop the contract. They went to the arbitration. Singapore, they filed a case. Okay, they filed. Then the hearings have done in the Singapore. They decide government that's owned by the government and they have to pay for the 30 or 38 million USD for the design company because they can't stop the contract. Cost of profit and those things they claim. So the main features is this is a fast and less formal than the court litigation. So the background of the arbitration act. Arbitration number, the number is 11 of 1995, certified on 30th June. Earlier it was arbitration audience in small mistake on this 1989, but based on the reciprocal model law of the international commercial arbitration, we established that one applies to both domestic and international arbitrations. Objectives of that, why this act is passed. So because as I said, there are so many disputes in the construction. Therefore you should have a effective and fair dispute resolution method. You need the legal method to resolve the disputes. Otherwise, you are going for the negotiation, mediation, whatever. It will not effective sometime. As I said, if the party is not willing to it, accept or what, negotiate, accept. You have to you need the effective method. So efficient method. Encourage the party autonomy and minimize the court intervention. So each and every case should not go to the court. So there should be another barrier. So the arbitration one of that. And also the purpose of that, create a modern legal framework for arbitration in Sri Lanka. Improve Sri Lankan position in the neutral seat of arbitration. So that sometime, so the international people also, they follow our arbitration act when they are performing their contract here. Align with the international arbitration standards. So UNICITRAL is one of the standard we are commonly use. I'm not going to discuss that's a more legal side. So I just give the importance and the beneficial advantage how to use like that. Not going to legal deep on the act. And also provide legal recognition to the arbitral awards. This will give a backup protection for the investors. You know that there will be a arbitration case in the Waters Edge. The investor won the case. So if you have a good system to resolve the disputes, investors are not scared. So they will, if you have a good system, they will invest. If you have a weak system, they are scared. It reduces the burden of the legal system. As I said, that most of the cases end up without the arbitration, not go to the litigation. And also enable faster resolution of construction and commercial disputes. So key features of that, section 5. So this is a must. All students should know they in the arbitration agreement must be placed before proceeding. Otherwise, you have to include in the contracts document. Without agreement of the arbitration, you can't proceed. And also, both parties has given freedom to identify the nominate the arbitrators. Then also their equal treatment and right to be heard. Award is a final and binding. You can't challenge that one arbitration issue. If there's a mistake, you can challenge. For example, no, I will discuss this later as well. So you are going. So the first dispute happen, we go for the arbitration. And for example, contractor won this one. But you can, that is the final decision. But if there is a no arbitration agreement, it's void. Then engineer can challenge that. If whether he really agree to proceed with the arbitration, but there should be a valid agreement. That's why I say limited ground for setting aside the awards. Advantages of arbitration under the Act. Speedier resolution than the courts. Confidential process, this one. And enforceable award both locally and internationally. That's the most important, as I said. Investors are accept this because it's internationally recognized. Expert arbitrators can be appointed. You know that in the ISL, Institute of Engineers of Sri Lanka, that ICTAD, they have arbitration panels. They have experienced people. They will recruit such people. So because need the experienced guy to resolve the problems. And also promotes the party autonomy. And also it minimizes the delays from procedural technicalities. This is what I say, that agreement to the arbitrate. Under the Section 3 of the Arbitration Act, that it's given that can be contain a signed document or an exchange of letters. Telegram or other means telecommunication which provide a record of the agreement. There should be a proper agreement. Okay. Give me 1 minute. So that you need a proper agreement. That because without agreement, sometimes it's not valid as well, because as I said, the parties can challenge it. Then the Section 4 above Act provide that an agreement, any dispute can be determined by the arbitration unless in this matter respect of which the arbitration agreement is entered into is contrary to public policy or it's not capable to determine by the arbitration. So it's continue with that one section. For any dispute which the parties have agreed to submit arbitration under the arbitration agreement may be determined by the arbitration unless the matters in respect to which the arbitration agreements are entered into the contrary to the public policy or it's not capable of determination by the arbitration. So these are also very important. So then the section 5 of the Act, we are party to an arbitration agreement, institute legal proceedings in court against another party to such an agreement in respect to matter agreed to submit for arbitration under such an agreement. The court shall have no jurisdiction to hear and determine such a matters in other than if the other party objects to the court exercising jurisdiction in the respect to such a matter. So that kind of scenario can happen. So they can go to the court in some instance cases. So notice of arbitration. The notice of arbitration may also include the proposal of the appointment of the sole arbitrator and appointing authority, the notification of appointment of the arbitrator, a statement of the claim. These are the notice of the you have to include. The notice of arbitration provides notice is issued under section 67 of the condition of particular applications commence arbitration in accordance with the ICCC rule. In the claim made, so ICCC Construction Council. Okay. The claim is a notice not satisfied within 30 days proceed with the ICC arbitration. Without prejudice to above, if the B agrees A is willing to submit the dispute to local arbitration under Arbitration Act that submit the dispute to mistakes local arbitrate. However, we shall communicate this decision within 14 days. These are the time limits. This is for your knowledge only. Okay. So you can. I will share the Arbitration Act as well, the long document. But that's you need the legal consultation for this one. These things to proceed, especially if you are sitting as arbitrator. If you have a dispute resolution or whatever masters or something, you can sit as an arbitrator. Then you should thoroughly aware these things. Actually, if the B responding within 14 days, if he's failed after nearly 3 months, 31st ICC arbitration by submitting claim to ICC with a copy of to B. So claim can be submitted. Well, this for your information. The notice of arbitration provides A stands B agreement to submit a local arbitration is not valid as the offer made by A expired after 14 days. Thus A says that only ICC arbitration is valid. So B stand A issue a notice of arbitration suggesting local arbitration according to Section 18 of the Sri Lankan Arbitration Act. Arbitration proceedings are deemed to be commenced on the date of the notice of the arbitration received by the respondent. So this is the award. Normally award, not normally, the procedure is that it should be given by the written and signed by the arbitrators. As I said, most of the cases, 3 arbitrators are sitting, 3 or 5. It's based on your agreement. They all has to be signed. State the reason upon which is based, unless the parties have to agree on that no reason are required. So what is that? So if you are giving a vote, reason need to be submitted, stated in the document. If not, you can avoid that one if the both parties need to agree. Otherwise, it has to be mentioned. Okay. I think that, for example, now, so the tax purposes, if you are paying to someone interest, okay. So interest case, so you are getting delay payment, you are going for the arbitration, you are getting the interest on that. That should be mentioned in the document, because that you can get it, you have to pay the withholding tax and everything for the interest. So you need the proper document. And the state the date and place of the arbitration. And also that your arbitration report is very important, because bad debts, contractor said engineer has to pay. It's keeping your P&A. Okay. So you want to write off that one. You can't write off he is not paying. So IRD will not allow that. You have to get the proper legal action to before write off. Then the arbitration decision is required. Okay. When you are signing the document, it should be the place and the date. It's very important. And the be final and binding subject to the part 7 of that. There are some clauses in this part 7, except that one. This is binding. The enforcement of the award, part 7 of the Arbitration Act, section 31(1). Award can be enforced by the High Court on the application made by the High Court within 1 year after expire of 14 days of the making the award. So that this can be enforced by the High Court, subject to provision regarding setting aside the award. The High Court shall on day notified to the parties proceed to file the award and give a judgment according to the award. Upon judgment so given, decree shall be entered. Thus, decree so entered shall be executed like any other decree of the civil court. The award can be set aside by the High Court on application made within 6 days on following grounds. So this is how to challenge the arbitration award. Where the party making application for furnish proof that the party that, as I said, the party to the arbitration agreement was under some incapacity or saying the agreement is not valid under the law which the parties have, subject it to failing to an indication of question under the law of Sri Lanka. Because sometimes people get signed the agreement when hearing is starting, and incapacity means that what you are, they are forced to sign like that. Okay, so then the arbitration is not valid. The party making an application was not given proper notice of the appointment of the arbitrator, or arbitral proceeding was otherwise unable to present his case. You are not nominating properly arbitrators. Then also it will be a you can the award deal with the dispute not contemplated by not falling within the submission of arbitration or contain decision on matters beyond scope of submission of to the arbitration. Beyond the scope of the sometimes you are giving the arbitration decisions beyond the scope, then it is invalid. You can challenge, not invalid, you can challenge. If the decision on matters submitted arbitration can be separated from those not so submitted. Only that part of the award which contain decision on matters not submitted to arbitration may be set aside to the composition of the arbitral tribunal or the arbitral procedure was not in accordance with the agreement or the parties unless such agreement was in conflict with the provision of the act. In absence of such agreement was not in accordance with the provision of the act. Any conflict with the agreement and the act, then also setting aside the award. Where the High Court can find like that the subject matters that dispute is not capable to settlement by the arbitration under the law of Sri Lanka or arbitral award is in the conflict within the public policy of Sri Lanka. As I said, the normal policy, the tax policy. So tax policy, so you can't, that is a Sri Lankan government, the law or imposed law, and all are under that one. So the award is given against that sum, then it's not valid. For this not happen, but for example, VAT. I'm just this I just explain how to explain this case that VAT, you have a conflict between the VAT or dispute in the VAT. You are paying that, so arbitration decision coming to not to pay VAT. But government, as the government policy, you have to pay VAT. Okay, then the you can arbitration decision can be kept aside by the High Court. So negotiating for the dispute resolutions. What is a negotiation? So negotiation is a voluntary informal process where the parties is where parties mutually accept the solution through decision without involving third-party decision makers like arbitrator or judge. For example, as I said, contractor client, contractor subcontractor, consultant and employee. Okay. It's very important you are going to do the preparation works. Some people are going to the meeting without no proper details. Even they don't have proper documents. Sometimes they are saying that given statement are very not valid. For example, the project is delayed because of last heavy rains, bad weather, not specified, not quantified, no details. Actually, they don't know when it's rain. So it's very important to keep the facts and also contract terms and dispute details. In the earlier lecture I explained some contracts adversary are not allowed when you are doing the port construction, breakwater. You should know the high tides. The whole year is not like a low tide level. So that's a high tide. It's a common. You are expected that one. Sri Lanka 250 days are raining normal. If it is adverse, yes, normal rain we are not going to pay. So contract terms you have to keep very, when you're going for the negotiation, it should be very thoroughly you have to keep it these things and very knowledgeable on that. And also it's very important. What is your final goal? Understand what you want. For example, for the delay claim. So as an engineer, who know there's a delay, reasonable delay, you want to give a EOT, but not the extra, the big EOT, the extra EOT, the extravagant EOT. But you can give a reasonable one. So that is your intention. And also, you should have a sense what is the contract also want when you are going to that. You know contract is request 30 days, but you know that they will happy with, they may satisfied with the 20 days. So that's the negotiations. You have to go, you know what is his requirement. Sometimes he need only extra days only, no prelims. So that's his intention also you have to understand. Then the interest-based negotiations. That's very important. Focus on the underlying interest, not just started positions. Example, for the contractor may request time extension position, but the interest is avoiding penalties. As I said, they are requesting days, but not getting the prelims. The engineer also want to give extra time, but not the prelims. That is the intention, interest on that. So this background, number 3 is a background that we call best alternative to negotiation agreement. Know your fallback plan if negotiations fail. If no agreement is reached, proceed to the arbitration. So you are going for the negotiation. You try to bargain, negotiate the interest, but it's not happened. What to do? You should have a backup plan. So you should go with the your second plan is go to the arbitration. Other time you can get a expert. So if the negotiation is not successful, at least you can get agreement with to involve the expert. So these are the common negotiation strategies when you are doing the negotiations. Separate people from the problem. It's most important thing. stay professionals, don't let personal, emotional, detailed discussions. So because people are going there, ask how are you, what happened to your leg, are you okay, what happened, what you happened, or how is your mother, father? Don't ask those questions. More professional. And also it's important to focus on the issues, not the individuals. The second strategy is focus on the interest, not the position. Ask why the party wants something to uncover hidden needs. So because when we don't know what is the actual requirements. General options of mutual gain. Collaborate to develop creative solutions. So, for example, when you are saying so that you have to pay the penalties, you have to pay the interest. No, IRD is doing the same thing. They say they're forced to pay the penalties or taxes with the penalties, and they give a installment pay to pay that. Okay, as a contractor, the engineer, the client is not paying, and also you also in a loose position because you don't have a jobs. You can't go for the termination, so then you can't cater your staff. You also little bit flexible and say, okay, I will give a payment plan for you to pay my amount. I don't want to terminate. I will slow down the work. I will minimize my overheads. Understand? So mutual gain is more important. So negotiating the construction contents. Usefully early in the disputes before delay escalate the damage and relationship. If the dispute is coming, if you are knowing it's coming, please attend. Otherwise, it will be a disaster in the end of the project. So, for example, so you are sitting in the meeting and contractor say now the bad weather is because of the bad weather, the project is delayed. Send official communication to the contractor. Please submit your program based on effect of the bad weather. Be ready and try to resolve in early. And also can be formal. As I said, do the proper documentation and meetings like that. Informal discussion via emails or site meetings. So informal means that you can discuss in the meeting. All often conduct under the framework of FIDIC contract clauses. And FIDIC allowed that one in the clause 20.5. Amicable settlement. So why it matters? Save time and money. We discuss these things. Preserve working and relationships. Maintain project progress. Keep the dispute out arbitration. Sorry. Role and responsibility. We have few slides and we have time today. Roles and responsibility of the negotiator. Role of negotiator in construction dispute. Neutral party or representative of one side. So, facilitator of communication. Facilitator of communication. Bridge the gap between the conflict parties. So that means sometimes when the sites are very hot, always contractor and client consultant, they have fighting. Not the fighting, they are argument, disputes, disagreement. But when the companies, big bosses are coming the side, they are all are settled. They look business relationship. So negotiator also doing the same thing, bridges the gap between the conflict parties. Ensures each side is heard and understood. You have to listen both sides and understood their problem and check whether their capability of the what is there can accommodate through the contract, promotes clarity, empathy, and dialogue, build of trust, help reduce hostility or defensiveness, build credibility by showing fairness and neutrality. So you have to make a trust with the both parties. If you are independent negotiator between two parties, you have to win their hearts, their trust. and also find off the common ground, identify the shared goals, project completion, cost control. So when you are going to negotiate, so you have to give options how to increase the project progress, cost control. Then you have to listen to their proposals, because contractors are also now very experienced and very talented. So they are so they also know everything, most of the things. So they will give the cost control plans. So you have to discuss those things, and also focus on the interest, not rigid on the positions. So these are the main responsibilities of the construction negotiator. Know the contract details. So he should understand the key contractual terms in the FIDIC clauses. So that what are the, so he should know what is the variation, all the clauses, not the specified one. What is the, how to handle time delays, prolongation claims, value variations. Without knowing the contract clauses, you can't do it. And also reference clauses during negotiation to guide the fair outcomes. The most important is remain neutral if third party negotiate. As I said, then so you can be a third party negotiator, not the. So then you have to listen for the both sides. No? Don't go to do and one favor for one party. So you should have as a negotiator, you should have ethic. Professional ethics are more important. And build trust by treating all parties fairly. Encourage collaboration. Promote problem solving rather than finger pointings. Recommend win-win solution. During the negotiation, don't finger out particular person or that. Don't try to promote the problem. Maintain confidential. You have to keep the discussion private and build trust. Don't go and talk outside. So this is very critical in the ADR and pre-arbitration stage. These are the essential skills of the good negotiator. Empathy. Understand the emotional and the practical concern of the parties. For example, that we did the studio project in Palavatta. Contractor request the contract say the advance payment 20% of advance payment give the mobilization time, other balance 10%. The other balance 10% will give the after completion the ground floor. Then that time ground, it mentioned the ground floor, but contract has construct that as per the agreement they release the 10% at the mobilization. But contractor, without completing the ground floor, he has done the first floor element, because that is a construction plan to accommodate the site works and site facilities. Then the client said he cannot pay the balance 10% because you have not complete as per the agreement, not complete the ground floor as per the agreement. Then consultant firm get involved to negotiate, and they explain to client. So the work quantity, what we estimated for the ground floor, the contractor is performed more than that. But because he has done some first floor work, columns done, reinforcement brought into the site, bended and keep it inside. But the work done is much more than the expected. But as per the contract clause, it said until ground floor complete, they are not going to release the 10-second balance advance. The purpose of give the advance to purchase the material, like that. Contractor also gave the bond. That kind of negotiation time, you have to think about the practical concerns of the parties. And also that we discussed the communication in the earlier. Effective communication, speak clearly, actively listen. So you have to listen both parties and articulate the positions. So communication is the most important. And critical thinking, analyze situations, foresees the risk, and evaluate the proposal logically. Patient and persistence. Negotiation takes time and multiple rounds. Within one day, you can't do everything. You need sometimes times. Today, they might not agree, but second day, they might agree. So that is your skill. It is emotional cases, you take time. So introduction to the arbitration process. So I think this one I have gone through. I will skip these slides. So this is the this what I want to discuss with you. Keep this, remember. This process is more important for you. First, you need the arbitration agreement. Based on that, arbitration appointment of the arbitrators. That is the second. Okay. Then the statement of claim and defense. The claim has to be forward. Okay. And the defense party has to give their statement and their required details, information need to submit to defend their claim. After that, you have to go and hear, you have to have a hearings and the final award. Importance in the planning stages. Why consider arbitration during the planning? Is incorporating clear arbitration mechanism at the start of the project. Ensure that all parties know how to dispute will be handled. Should they occur, this help avoid confusion or legal battles over adjudication or process. And also that, as I say, if in the contract you are binding, so when you are doing the construction contract, if you include arbitration agreement, so then it's binding document. So planning is most important. So the later part, you can't have an agreement with the dispute. Sometimes Disadvantages people side, they will not agree for the arbitration. In the beginning of the project, both parties are in the equal basis. So better in the beginning of contract include the arbitration agreement. So these are the key reasons arbitration is important in the planning stage. Avoid future delays. If the dispute arises in no clear resolution method is set, parties may end up with lengthy legal arguments over how to resolve it. So these are the disadvantages that we earlier discussed. It's also same thing, but including arbitration clauses early prevents project standing. Prevents project stand still and ensures smooth continuation. Provide a clear dispute resolution path. A well-draft arbitration clause. In the FIDIC, yes, you have a well-draft one, so you don't need to amend it, but it's defined the basic requirements, number of arbitrators, language. Formally, we use the English, seat, location, or arbitration, applicable rules, under which rule we are listening the case. This reduces uncertainty and improves the fairness of the parties. For example, some cases that so you are listening, hearing in Singapore, the applicable law is should be the English law or Sri Lanka Roman Catholic law. So likewise, that the applicable rules or legal requirements has to be stated properly. Reduce legal cost. Pre-agreed arbitration is more cost effective than going to court without prior agreement. Parties avoid the cost, procedural challenge and judicational battles. And also that, as I said, stakeholders and investors are very confident if you have good arbitration clauses. They impose to put, because otherwise they will have in a disadvantageous seat. Well-prepared contracts show professionalism and risk management. Investors, lenders, and ensure prefer projects with dispute resolution safeguard in place. Ensure compliance with international standards. Especially for international construction projects, arbitration is a standard for cross-border disputes. Planning for arbitration helps align the contract with global practice. Litigation. What is the litigation? Litigation is a process of taking legal action through the courts. To resolve the disputes in the formal, structured, and public method of dispute resolution, where judge or someone in the jury delivers a legal binding decision. Advantage of litigation: the court have legal power and their decision carry full enforcement, of particularly useful in the complex of high stakes in the construction cases. Appeal process: unlike arbitration, in the litigation you have a appeal. You can, as per the applicable law, you can go for the higher court. If you believe there's a error is happened, you can go for the higher court. There are so many decisions challenging the higher court. No. Change. They will change. The disadvantages of the litigation is that construction case can take years to resolve due to the court backlogs. The Sri Lankan courts are full with the cases. They have it. Therefore, it takes times. Costly. Legal fees are very high now. Sometimes one sitting, the presidential counsel getting huge amount. So that is their profession, no doubt, but it's costly. So, and court fees make litigation the most expensive dispute resolution method. Court cases are not confidential, so then it's very exposed to public. So advice is not to. So the better to keep it within the company or within the parties. So what is the litigation appropriate in the construction? When the enforcement in the judgment is critical. So the payment is no non-payment or large sum. So this is a criminal case. And serious legal issues like fraud and negligence arise. When the one party refused arbitration or non-valid arbitration agreement, as I said, without proper agreement, you can't go for the arbitration. So, but you can go for the litigation. When precedence settings is important. Example, clarify legal ambiguities in contracts. So, that's all from my side. So, this is a very boring subject, but when you are involved in the construction, it's easy to understand. But anyway, these are the course contained, so I am discuss it today. So, any question from your side? We have another 20 minutes, so we can discuss any matters. So you have to know about the especially advantages and disadvantages of the ADR methods. What are the restrictions and requirements of what are the loopholes to overturn the arbitration decisions, etc. So those are the very critical, and also that general requirements for the effective communications. Okay, so any questions from your side? Okay, then we will wind up today. I don't know whether you have assignment on this. It's not informed to me. So I include the note in the chat, so you can get download. But I will share with the university as well. Okay, thank you very much. Good evening to all.
Thank you, sir.
Thank you, sir.
Thank you, sir.